All right, then we'll get started with Ms. Baum right now on the record, and I guess that's our plan at this time until we know who's going to represent Mr. Blackwell. All right, on the record in state of Michigan versus Jessica Lynn Baum, 2303381FY.
Your Honor, good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Good morning, Your Honor. John Ryan, P number 84120 on behalf of defendant Jessica Lynn Baum. She is appearing by Polycom from the Ingham County Jail.
Sure. And you are Jessica Baum on the video?
Yes, ma'am.
All right, thank you. Today was the date we had originally left set for preliminary exam, but of course at that time we knew that Ms. Baum was still waiting for assignment of counsel, which she now has. And also now a third co-defendant has been arrested and arraigned with a date set. It's my understanding that the attorneys had already previously discussed the need for Mr. Ryan to get up to date on this case, and therefore an adjournment is in order. Is that right?
Your Honor, that's correct. I did have an opportunity to speak to both Mr. Ryan and Mr. Yang, and we did discuss that while the people are ready to proceed to preliminary examination here today, Mr. Ryan in particular, because he was just appointed, needs some additional time to review the discovery, meet with his client, and prepare. And we believe that good cause exists for an adjournment, and we do not object. The people would waive our right to preliminary examination within 21 days, Your Honor.
I think rather than make Ms. Baum waive her rights, I'm just going to find good cause to adjourn and set this out for December 14 at 10 a.m. Of course, we know because there is going to be a third defense lawyer involved that there's a chance that that attorney needs some prep time as well. But that's our plan right now, knowing that that's 2 weeks out, that it's our hope we can move forward on December 14th. Are there other matters we need to address for the record today on this file?
Nothing for the people, Your Honor.
Mr. Ryan?
No, Your Honor.
Okay. All right, December 14 at 10 a.m. You're all set. Ms. Baum, I'm not sure if they're intending to use that Polycom for someone else, but you're all set. You can let them know and they can send in the next person.
Thank you.
Yeah.
Thank you, Your Honor.
Thanks, John.
Yeah, thanks, Bill.
Oh, hello. What's your name?
Ileana Jackson.
Oh, good. Mr. Yang, you said you're ready.
I am ready.
Okay. On the record in state of Michigan versus Ileana Jackson, 2303382FY.
Your Honor, good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Jackson, who is joining us via Polycom from the Ingham County Jail.
And you said that you are Ileana Jackson on the video. Is that right, ma'am? I didn't get any audio. Can you try again?
Yes, ma'am.
Oh, thank you. Today is supposed to be the date for preliminary exam, but since I last saw you, a couple things have happened. Ms. Baum obtained new counsel, as well as Mr. Blackwell was arrested and arraigned. So we have the issue of, I believe everyone agrees an adjournment is in order to consolidate the preliminary exams and allow time for counsel to prepare. Mr. Crino?
Your Honor, that's correct. As I indicated on the prior record, counsel and I have had an opportunity to speak, and I've spoken to Mr. Yang on multiple occasions. While the people are prepared to go to preliminary examination today, we do believe that good cause exists because counsel needs additional time to prepare, and also because there will be a joint preliminary examination in which there was a newly appointed attorney. So for those reasons, we do believe good cause exists. And as necessary, the people would also waive our right to examine within 21 days.
And I guess to be clear, Mr. Blackwell is actually scheduled to be arraigned today, but we have dates scheduled. Okay, Mr. Yang.
Thank you, Your Honor. I have spoken to Ms. Jackson about her 21 days. She's prepared to waive that, but I've asked that the court find good cause anyways due to all the circumstances surrounding this. And so she was aware when the time is right. I would like to respond.
Okay, I do find consolidation with the co-defendant case is appropriate. There's good cause to adjourn. I will reset this preliminary exam this time to December 14 at 10 a.m. Of course, keeping in mind that we may end up having to address this again as counsel is appointed to Mr. Blackwell, unless he retains, but even then, we'll see. As to your motion for bond, Mr. Yang.
Thank you, Your Honor. I was able to make contact with an uncle of Ms. Jackson who lives in the Van C area. He is willing to have her be released there and is willing to make sure that she's transported down. She's originally from that area. Her current bond is 10,000, 10%. I understand this
It's not. It's 10,000 cash surety.
It's 10,000 cash surety. I apologize for that, Your Honor. I'd like to request a PR bond with GPS tether. She's 18 years old, has no prior history. I understand the nature of this case as well as the underlying case is a serious charge. But I was able to secure this uncle's information. This is far away from the area. I have had multiple conversations with my client about communication about this case, which should only be with me pretty much. And so at this time, I would like to request a PR bond with GPS tether. She has no funds, won't be able to post anything. But due to the nature of the case and the underlying case, I can provide, if Your Honor would allow me to approach the address and phone number for this uncle instead of putting that on the record. But I would like to request a PR with GPS to this uncle's address. I believe she, based on the financial information she provided to me, she should be eligible for a grant money GPS.
And she will have transportation to return for hearings?
That's correct. That was my other concern. We actually was in contact with another family member who she could stay with, but they would have had transportation issues. So this uncle said they have multiple family members and they will make sure that she is here for all the dates. So.
Mr. Crane.
Your Honor, thank you. As the court is aware, MCR 6.106C indicates that there is a presumption of personal recognizance bond. However, that presumption of personal recognizance bond can be overcome where the court finds that a bond is reasonably necessary to ensure the appearance of the defendant as required, or that a personal recognizance bond might present a danger to the public. And I understand that the court was the arraigning magistrate or the arraigning judge, excuse me, in this case, and determined at that time that a $10,000 cash surety bond with conditions was necessary to both assure this defendant's appearance and also to protect the community. So I think that the only thing that has really changed potentially since the time that this court set the original bond is the fact that there now is someone who will vouch for this defendant who is out of this area. So I don't know if that's sufficient for this court to modify its original findings. However, as it relates to the danger to the community, I do want to be heard on the record as it relates to that, Your Honor. Mr. Yang is correct. This defendant is 18 years old. She has no prior record. We do not have an updated bond report, or at least the people do not have a bond report indicating that she has any failure to appear or non-appearance in court, or that she has a substance abuse addiction or a mental health condition. Under factor FE, Your Honor, the court must consider the seriousness of the offense charged, presence or absence of threats, and the probability of conviction and likely sentence. What's critical to the people, Your Honor, under that bond factor is the presence of threats. This case is about threats, and from the jail calls that we listen to, from the witness testimony we anticipate, And now from information that we have obtained from the third co-defendant during our investigation, it appears that this defendant was actively involved in soliciting other people to threaten witnesses in a homicide case, threaten witnesses with physical harm and gun violence. This is an acute situation, as I indicated last week at the PCC, as it relates to Ms. Baum. The preliminary examination on the homicide case, which is the underlying event that this case currently involves, is set for preliminary examination before Your Honor tomorrow. So this still remains an acute situation, given this defendant's involvements in actively both directly speaking to witnesses and soliciting others to violently threaten those witnesses. That presents a problem for the people in terms of the court's assessment of, is she a risk to this community if she is allowed out on bond? In terms of a responsible member of the community that will vouch for her, it is additionally concerning that she will be leaving Ingham County if she is released. She will no longer be in the area. And the people, and I of course trust what Mr. Yang says, however, the people know nothing about this individual to whom she is allegedly going to be released in Manistee. So these do cause us some concern, Your Honor. Ultimately, I will leave the bond decision in the court's discretion. I think a different circumstance exists with this defendant than did with Ms. Baum, who has an extensive prior record of violence and narcotics convictions. But I will leave the decision in the court's discretion, understanding that the people do have concerns as it relates to the safety of the public, which is one of the reasons that we can overcome the presumption of personal recognizance bond. Thank you.
Mr. Yang, I'll take that address from you, please. Let me see. Thanks. Do you know, is this a maternal uncle, a paternal uncle?
It is a paternal uncle. Her grandparents live there as well, so she's from the area. Ms. Jackson.
Sure.
From the area.
But her co-defendant is her mother. So I want to know if this person has a relationship to that co-defendant.
I believe it's a paternal, not a maternal. Let me see.
If you can sort that out.
I would square that. Ms. Jackson, is Mr. Shaw your uncle on your dad's side or on your mom's side?
Mom's, I don't talk to my dad's side.
Okay, thank you.
And so therefore the grandparents are possibly her mother's parents. You see how this gets complicated?
Understood, Your Honor.
I hear your intentions are good, but because of the relationship there, it makes it extra complicated.
Perhaps I could request a updated bond report for our next court hearing, the 14th. And that will really answer some of the questions that maybe the court and the people have. There were multiple family members who said that she could be released to them, but transportation was the number 2 issue. And they're all related. It's paternal, maternal. So it's. Then Mr. Shaw reached out to me. He was adamant she could stay with him. I understand the court's concern. I understand the people's concerns. Like I stated earlier, the underlying case is a major crime, but with these postponements, I'm not sure how long it's gonna take before we get to the hearing itself. That's my request. If the court would feel better if we had an updated bond report, I can request that ASAP or to have it by the 14th. But that is my request for bonds.
So a couple of things that sort of change the position we're in today are that the co-defendants, at least the ones that are charged in this case, are both currently in custody. I don't know what Mr. Blackwell's bond's going to be or his ability to post bond. So there's, I guess, less opportunity for the 3 of them to engage in continuing conduct. But there is a concern, of course, that Ms. Jackson, one of her own, could choose to engage in threatening conduct, as well as the relationship to the family member who's willing to vouch for her being also related to Ms. Baum. I feel like I would need assurances that he wasn't going to be somehow a middle person between Ms. Jackson and Ms. Baum and somehow trying to, well, one, violate the court's order of no contact, but two, also like continue some continuing activities related to all of this. So it's really a challenging situation. I do think things have changed somewhat, Mr. Crino, since I originally set the bond, but and the fact that she'll have a place to stay separate and apart from Ms. Baum is helpful, because at the time of arraignment, that wasn't clear either. It sort of sounded like, Ms. Baum was going to make Ms. Jackson homeless or something, and that was going to be a problem as well. That I thought they would probably just end up engaging in the same activities. I guess what I'm going to do, Mr. Yang, is I'm going to deny your motion right at this moment, but if further information can be provided to the court regarding the person that is intending to take Ms. Jackson into his home and provide transportation, I think that could be helpful. And I'd be willing to entertain that if we needed to set an urgent hearing or something. We can do that, or you can wait till the 14th. Okay.
Your Honor, would you like an official updated bond report or just assurances from the uncle? Just so I know how.
As an officer of the court, Mr. Yang, I would take your word for it. It doesn't have to be an updated bond report, but I do think you probably need to have some kind of discussion and get some information about what the plan is, because if this is Ms. Baum's brother and he's gonna take Ms. Jackson in, but then be the middle person for correspondence or something, that's just not gonna work. It is a difficult situation for family to be in.
Understood, Your Honor. Thank you. I will update the court as soon as I have something.
Okay. Anything else that we need to address for the record today?
Your Honor, thank you. Nothing for the people.
Nothing further from the defense, Your Honor.
All right, thank you.
Thank you.
All right, Ms. Jackson, you're all set for today. I will see you probably on the 14th, but your lawyer will be in touch.
All right.